Today we're going to be talking about industrial stormwater lawsuits, how to deal with them, how to understand what's going on and some of the root causes. We're going to look at some examples of some litigation around the country and specifically in California. I know we have a large California audience. Quick intro, I'm Ryan Janik. I'm one of the founders of Mapistry. I've spent about the past 12 years working largely on water issues, stormwater, both from an engineering perspective, and then over the past 3 or 4 years, integrating a lot of computer technology, software technology into the stormwater space, working with largely industrial facilities, some municipalities, but largely industrial facilities on streamlining their compliance programs around industrial stormwater permits, making sure their staff are trained, even dealing with these lawsuits that we're talking about today, working on fixing BMPs, reviewing SWIPs, making sure staff really know how to train properly. As you also joined by Nathan Metcalf, he's a partner at Hanson Bridgett in San Francisco. He's going to be talking more from the litigation legal perspective. I'm going to try to present on a more technical perspective today. As I said, Nathan Metcalf is a partner at Hanson Bridgett. We've worked together on a number of litigation cases related to industrial stormwater, but he's got a ton of experience in this space, not only in stormwater, but also in water rights and other water issues. So what happens in a lawsuit is storm event allegations. And I'm going to talk specifically about a rain log here, but quoted out, typically when an environmental group files this 60-day notice of intent to sue, they put an attachment at the back and they say that you have discharged stormwater having high levels of whatever contaminant is, TSS, on all these dates. And you're liable for penalties for all these dates, $37,500 a day for all these dates. And this is where one of the record-keeping things, it's not required in the permit to have a rain log. It's one of the reasons why we built in to do it automatically in our software. It really helps to push back against this if you have a rain log. I'm going to talk a little bit about how to kind of push back on or lawsuit prevention in a minute. But I want to mention before we go into that, as I said before, that facility had a regulator inspect that will likely lead to a lawsuit. I've seen that trend happen many, many times. But just some common inspection findings from a regulatory agency perspective. Sediment trackout's a big one. Missed reports is a huge red flag, especially with publicly available data. Dumpsters not covered, probably the most written up violation we see out there from inspectors. So if you get an NOV or an inspection report that says you're deficient, fix those problems ASAP to ward off the bigger problems. So to recap, companies get sued and fined. Sampling data is probably the number one. If you're not reviewing it, not collecting it correctly, not training your staff, that's probably the biggest reason. Number two is really bad records, everything from not having inspection forms to incomplete site maps to no SWIP. So review your data, get a really good system in place for managing all the requirements of the permit. What can be done to potentially prevent lawsuits, or if you're in them, it can help you push back against them from a technical perspective. So your stormwater program has a few key tenets. One is kind of core learning, training staff, educate not only the staff on the ground, but your execs, your boss, if you're a facility, any kind of execs, understanding and taking it seriously and not getting hit blindsided with $200,000 problem. Really simplify your program. I've seen lots of complex programs. A big thing I end up doing is simplifying it because I think it gets actually implemented, which is key. And then making sure you hit all the compliance. You don't miss storm events, you don't miss annual reports, you don't miss inspections. So staying on top of that. The way you do it is a couple things, is making sure you're tracking the weather. Know when you're supposed to sample so you don't get hit for allegations of not sampling. At the same time, keep really good rain logs and records around that. When we're talking about, your sample data is high and that's what you're most worried about, if you look at the root cause of that, it's probably because your inspections and your training aren't sufficient enough. Are you positive inspections are getting done? Is every inspection form look the same and say no problems? Understand that deficiencies need to be tracked, corrective actions, complete that loop and close that loop of I found a deficiency. Here's the corrective action. The corrective action was done on this date. Okay, I know it's fixed. And look at the data and see how that's going. And then just make sure you don't miss anything and you keep all your records in one place. For example, like when we do an inspection on our phone, In Mapistry, an email goes out to the whole team saying, the inspection was done, so that, met my requirement for the month. And here are all the deficiencies I found out there. And it really helps ease that communication. If you're not using something that's automated, you should be picking up the phone, you should be sending an email. It's a little bit more time intensive if you're not using something like our software, but regardless, you should be communicating out that an inspection was done. Here are the deficiencies. Here are, what needs to be done for it. The other thing is when the deficiencies get noted and you get a list of corrective actions, make sure that they actually do them. And you can see here where it says outstanding corrective actions, understanding this is from an email that we send out once a week that gets automatically generated as it tracks saying, it's been 6 months and two inspections found site sweeping. You haven't fixed it yet. Why are you not doing that? And it allows you to engage with a facility a lot quicker and close that loop before it shows up in your sample results. The other thing is weather. So when you get down to sampling, so inspections, training is the start. When you get down to the weather is making sure you don't miss storm events, you're prepared. I see a lot of problems where the kind of core stormwater sampling person isn't there, but the rest of the team doesn't realize the storm's coming, it's a big rush. They never got a warning a couple days in advance. It's another reason why we use software to do this is we can just look at weather data in real time every hour, even down to your own individual weather station, and send you out an email saying, hey, you've got a storm event tomorrow. Make sure you're ready to sample. Don't mess this up. The same thing is the rain log of being able to push back against lawsuits saying, no, it rained these days, yes, but here's why it didn't discharge or didn't rain these days. This is my site-specific rain log. This is all being recorded automatically. So from a paperwork perspective, it's pretty easy. But if from being able to push back from a notice of intent to sue, you can pull up records that actually have your site-specific information about the amount of rain, did it discharge, did you sample, et cetera. And those little icons you're seeing there on the left is from a site that actually sampled those days. And the final piece is, and a lot of you had said, how do I, I'm worried about my results. And we talked about, reviewing it. It's something we built in where you can just see if you're in compliance with benchmarks and ALs in real time, and you're not waiting to, wait till the end of the year or even enter it into Excel to understand how you're doing.
Hi, everyone. I'm Nathan Metcalf. I'm a partner with Hanson Bridgett in San Francisco. Prior to, I went to law school late, and prior to going to law school, I was a EH&S manager in the biotech and pharmaceutical industry, and actually wrote a SWIP back in the 90s when it was a lot less painful and easier to do. But those times have changed. So what I'll talk about is kind of the lawsuit process and where there are how there are ways to address the lawsuit to lower the cost, because it's going to lower the cost that you're going to end up paying, and tie in some of the themes. So I'll talk a little bit about the process. The first thing you're going to receive is a 60-day notice letter. And what's important about this is to take it serious and act on it. I've had a lot of clients who get the 60-day notice letter and they don't understand what it is and don't take any action on it. So under the Clean Water Act, you have to provide a 60-day notice letter before you file the suit. So when you receive the 60-day notice letter, start taking actions as soon as you can. The other thing with the Clean Water Act is that they have to allege ongoing violations. So it can't be solely past violations. So if there are deficiencies in your BMPs or there are deficiencies in your SWIP, if you fix those during the 60-day time period, you can remove those from a complaint that might get filed later. Unfortunately, there will continue to allege that any sampling violations that you have are going to be ongoing for every storm event that goes on in the future. The other thing that the 60-day law period provides is an opportunity to start talking with the plaintiffs and figuring out what your best strategy is for either litigating or settling, and most of these cases end up settling. We've talked about this already. So the typical terms will be discharges contaminated stormwater. They're always going to have some allegation that your SWIP is inadequate, tying that the inadequacy of your SWIP back to the exceedances of the benchmarks. The same with BMPs. As Ryan mentioned, they're going to look at rain logs and try and tie days that you didn't do inspections, or if you failed to take sample results, back to some sort of rain data that they get from a weather station, and then they'll claim that you falsely certified compliance because their allegation is that you did not comply.
Water board comes out and inspects and writes up findings, or a city inspector finds up. Are environmental groups still allowed to sue? What shields a discharger if there's like an active water board case? Is there certain things that do shield a discharger from lawsuits? Are there certain actions an inspector might take that do not shield a facility?
Yes, if they allege the same, but it has to be a violation. It can't be just they have to be some enforcement action. It can't just be like a notice of violation. There has to be an enforcement action. If it's for the same issue that they raise in their 60-day notice letter, they cannot pursue it, because the citizen suit can't pursue what the regulators are already enforcing. When these citizen suits first started cropping up, people would successfully go to the regional board, water quality control board, and ask them to come out and inspect and issue some sort of enforcement action or a notice of violation. And then there was some case law that made the notice of violation less enforceable. And then I just think because of budget purposes and the regional board didn't want to get involved in that type of action, you don't see it a lot much anymore, and the groups that are filing the claims would probably know. They would do their homework and know whether there was an enforcement action that would prohibit them from doing it. But that used to be a very viable defense. I just don't see it much anymore.
So a question about a 60-day notice. Say you get a 60-day notice and you fix all the problems that were outlined in that 60-day notice a week after getting it, and going forward you're in compliance. Is there anything they can do? Maybe if you want to speak about the difference between like a SWIP deficiency versus maybe previous sampling data.
Yeah, as we were talking, if you act on it right away and they've got SWIP allegations or BMP allegations, you could take care of those. The more difficult one will be that you failed to sample or failed to do your inspections based on, again, the rain data that they have, and the biggest issue is the sampling results. So both the 60-day notice letter, if they file a complaint, will strongly allege that you will continue to exceed the benchmarks or the numeric action limits, and it's pretty hard to. We would have to litigate it in order to show that you're not. But they'll say, based on your history, that every rain event going forward, you will continue to violate the permit because you're exceeding the benchmarks, and it's only through their actions that brought you into compliance. So therefore, they get they want their attorney's fees. If they've gone to the effort of sending you a 60-day notice letter, they think they've got a claim for future violations, and they're going to want either a settlement or to litigate in order to resolve that issue.
Yeah, and they can go back 5 years on your records. That's why, like in the permits, it talks about a 5-year record retention. They can potentially get all those records and put those in all the sampling data, et cetera.